Hi, welcome everybody. My name is Jeff Fowler. I'm with the Apartment Owners Association. So good to have you with us today. We're going to cover ADA compliance, and you're not going to want to miss it. We have someone who's going to be sharing with us out of 35 years of experience. He's got a 4-step process. He's going to bust some myths. You're going to love it. So stay tuned. Our goal here at the association is to help you make and or keep more money than ever before. And so we feel that this live stream is one that's definitely going to help you stay out of a lot of trouble and also take care of your tenants. And so, you have happy tenants and it just gets easier for you, right? And so one of the things that I'd like to highlight about the association is that we have a whole contractor and vendor list. And in the magazine, it's there every single month. On the website, you can go to the contractors and vendors page, and you'll see all types of services that are offered there. And some are insured, some are not insured, because we know that you're investment property owners, and so you don't always need that, but sometimes there's certain cases when you really do. Kind of like if you're going to do some work with this ADA compliance, you better have someone that's contracted or someone that really, really knows the law, right? And with this, if you're first time, you've never become a member of our association, there's a 100% money back guarantee. And so we'd like to offer that to you in your first year of membership. So please sign up. And just to let you know, last week there was a live stream about how to escape California. If you're getting to that age where you're done managing, then definitely would want to take a look at that one. And this afternoon we have another live stream, and then next week we have Dennis Block, as well as, let's see, smoke damage, minimize insurance claims, and maximize liability. So that's coming up, 2 different ones next week. You won't want to miss either one of those. And Dennis Block, he is Southern California. But he does speak to the whole state. So if you're not under specific rent control and you're in a different part of the state, it would work. The next week we have Beckman that's going to be speaking. He's an attorney from up north. So we want to have you covered. Either way, there's a benefit just from hearing about some of the state legislative updates. And anyway, so we just want you to subscribe if this is the kind of content that you want. And then we have an e-newsletter. Definitely get on that, and we can give you updates and keep you in the know, because if you're in the know, then you're going to be set up to be a professional investor and housing provider. And so today it's sponsored by ADA Design and Construction and ACR Concrete and Asphalt Construction. So these guys have been in business for 35 years. And they are improving access for individuals with disabilities. They are helping you take care of your tenants. And they also provide a lot of information. Our speaker today, he's been published multiple times. So he's always out there just getting out the information and helping people get access. And so this is it's important work that he's doing. And he's the president and founder of ACR Concrete and Asphalt Construction, and he holds licenses like the A, B, C12, C8, C32. He knows his stuff, and so you're going to hear from him today. I'm really excited to introduce to you today Tony Bichard.
Hi, good morning, and thank you, Jeff, for the kind words and the introduction. Do I need to share my screen again here?
Yes, please.
Okay, are you with me? You're seeing our presentation here with the ADA lawsuits. Great.
Yes, we got it.
Okay, again, thank you for joining us. My name is Anthony Bichard. I'm the president and founder of ACR Design and Build, where we specialize in ADA compliance and providing service for our clients that want to be proactive and should be proactive, and if they've ever been caught up in an ADA lawsuit. Now, this pertains to what we refer to, or the federal government refers to, as Title III. Title III consists of gas stations, liquor stores, nail salons. And what most do not know is that apartment buildings with 15 units or more. But we're going to dive into that a bit later here on a couple of our other slides. But if I may, at this time, do a couple introductions and disclosures. What we do here at ACR is very unique. We understand the importance of having a team with your ADA compliance, and the team consists of 3 principles that are critical in bringing a property into proper compliance. They consist of someone like myself. I view myself as the quarterback, but I am the designer and the contractor where we perform all of the corrections for exterior and interior in-house. In addition to that, everything starts with a CASP report. Now, a CASP report is something that is vital. It is the information that most attorneys will use and judges will consider in concluding what the corrections really are. So the CASP inspection is very important. Our CASP inspector is a gentleman by the name of Jason. Jason is not on ACR's payroll, and there's a specific reason for that. You want to make sure that your inspector is not part of receiving any compensation financially or otherwise in the construction or design process, because that's a conflict. Here's an example. If I perform the work, I cannot turn around and tell you that I did it properly. You need a third party for that. So we come together as a team, we work together as a team, and the same goes for our expert ADA legal counsel, which is Tina. Tina is not a part of ACR's payroll. She has her separate practice. We all come together to provide ADA compliance, and it is critical that you have a good team. So we'll talk a bit more about that as we carry on, why the team can take all the frustration and cut finances and the cost of settlements tremendously by working with a good team. But again, just a brief explanation of ACR. We can handle everything from new construction, correcting buildings that are 30, 40, 50 years old with a set of plans, permits, anything that the property requires to bring into compliance. Some of the properties may simply need some signage and some striping and things of that nature, but we can handle everything that the property will need. You won't have to go out and look for architects and things of that nature. So just a brief introduction about ACR. Next, the agenda, what we're going to be talking about today is ADA and the California Building Code definitions. Keep in mind, these are 2 entities, separate entities. Dispelling ADA myths. Some of the most common ones are grandfathering, landlord responsibility, construction standards changing. And then lastly, we're going to go into 4 steps. I have here 4 simple steps to ADA compliance. How to be proactive. And again, the team approach. You're going to hear me speak of the team approach often today because we believe it is critical. The proactive with the CASP report, the ADA design, ADA corrections, and the most critical of all that we believe is the CASP reinspection. Now today, for the purposes of our live webinar, ACR will be providing a free CASP report to a particular winner that will be found or identified later today. And it will be an initial inspection and a report. So make sure that you participate with that today. But the most critical will be the CASP reinspection. So we'll go into why that's important as we come up on the slides here in a few moments. American Disability Act, ADA and the California Building Code. So what I want to do is jump into some clarification here, where a lot of owners that have taken it upon themselves to dive into this ADA arena and try to figure it out. The Americans with Disabilities Act of 1990, referred to as the ADA, we want to make sure that we add some clarity between the two. Is a federal civil rights that prohibits discrimination against individuals with disabilities and requires that all public accommodation and commercial facilities to be accessible to individuals with disabilities. So keep in mind, this is law, this is code in California. So we always want to refer to what the intent of the law was really designed for. So if you always work with ADA compliance as your foundation, that it is law and what the intent is, you'll come away with a better understanding. Now, the California Building Code contains the construction-related accessibility provisions that are the standards for compliant construction. A facility's compliance is based on the California Building Code version in place at the time of construction or alteration. Alteration is probably the key word in this entire paragraph. So what we want to do is understand that California Building Code describes how to perform the accessible route. Most owners are confused. They believe that the parking lot, which is where accessibility starts most often, that the only thing that's required is an ADA parking stall. Well, that's not necessarily true, because the law requires an accessible route. Not all disabled persons operate a motor vehicle, only 65% roughly, approximately. So the other 35% of disabled individuals are navigating on the public sidewalk through public transportation. So there needs to be an alternate route called an accessible route from the public sidewalk. Now, how you create that comes from within a design. When you put the design together, you refer to the CAST report for the corrections. Then you put into effect California codes, the building code, and the ADA code. So there's two different entities here. Oftentimes when the owner is navigating through, he'll find principles such as a contractor or the CAST inspector or an attorney. And a lot of them will try to do a service for their clients. In my opinion, it's a disservice by telling the client to try to figure out something within the building code that will keep them from complying with the federal law. And what they will do is use this sentence right here, California Building Code version in place at the time of construction or alteration. So what a person or a principal may do is tell the business or property owner that, hey, your property was in compliance when they built it in 1950, so you do not need to make these alterations because you did it in 1950. Again, key word, alteration. If you alter the building, here's a perfect example, seal coating the parking lot and restriping it, which owners do typically every 2 to 3 years. That requires a permit. That permit will trigger compliance through, right now would be 2019 building code. So if that were your argument, why you were not complying with the law, you will have a very difficult time defending that position. So again, if you always remember what the intent of the law is, you'll be able to have a better understanding. But the more you perform research, you're ultimately going to find someone that says, hey, you do not need to do this. The problem with that is the person that is going to file a lawsuit against you does not know your position ahead of time. Once that lawsuit is filed, you now have to go through the settlement process to work yourself out of it. Now, if you decide to defend the process or that complaint, you may find yourself defending a poor position, and attorney fees may run $20,000, $25,000. Keep in mind, you are now going to have to pay the fees for the plaintiff's attorney fees. They will be requesting those as well. The longer you defend your position and you carry it out, the settlement costs typically go up. So you may find yourself in a position where you could have settled this lawsuit from $5,000 to $15,000. You may find yourself 6 months in with $50,000 in attorney fees, and still lose and have to make the corrections on top of it. So our advice and our opinion is, if you have a CASP report and it says you have corrections, bring the property into compliance correctly the first time so you do not have multiple lawsuits. So if keep in mind, again, and we'll leave this slide with, pay attention to what the law and the intent of the law was originally designed for, which is bring the property into compliance. So we're going to jump into some of the most common myths that are out there. If your property is open to the public, then it must be accessible to individuals with disabilities. Misconceptions about these standards may leave you unsure about the compliance of your facility. So again, these type of properties are considered Title III, apartment buildings, 15 units or more, and the reason for that is, again, the leasing office and the manager on site. It has been argued in multiple federal courts that the manager's duties or primary duties are, one, to meet potential tenants, to provide applications to tenants, and to show units for potential tenants. If that is true, then you must allow disabled persons the same accessible opportunity. So that means that you have to create a accessible route to the manager who may be on the second floor. So you may create what we refer to as a satellite office in a common area, but that comes down to the correct design. And oftentimes there's a lot of confusion on this as well. If you notice it at the bottom of most of these slides, it has my email. Feel free to email me any questions, or if you have any properties where you want a free evaluation, not a CASP report, but just a simple free evaluation on what you should do, your next step, then feel free to write the properties down. You'll be surprised how fast I get back to you, and you'll be on the right track to get this property into compliance. So coming into the actual myth, my property doesn't need to be compliant because the building is old and therefore grandfathered in. But here's the fact. There are no grandfathering provisions. Grandfathering is the notion that ADA requirements do not apply to buildings constructed prior to the establishment of the ADA. This, however, is not true. Regardless of the age or historical importance of a building, if it is open to the public, you must provide access to the goods and services you offer. Now, when you provide the access or the accessible route to the entry door of your property, restaurant, nail salon, what have you, it must be constructed according to ADA requirements and California code. California, the California Building Code 2019, which is what we are currently using, has a section 11B for accessibility. And it is quite extensive on how to bring these properties into compliance. So that is the myth. The property must be brought into compliance according to ADA. And again, you may find someone out there, according to California code, that says that you do not have to do it because the property was in compliance in 1950. But here's an example for you. We had a client that came to us about 2 months ago, he had just put in his hair salon a $10,000 service counter where you pay for your service at the hair salon. It was beautiful. It had granite. It was very modern looking. The problem with it is the property owner did not hire an ADA contractor, one, nor did he pay attention to any type of permits or any of the codes. The contractor did not have experience. He did a beautiful job, by the way, but he built it 42 inches in height. Problem with that, and here's the difference again between ADA and California codes. The most stringent must apply. ADA states that your service counter must be a maximum of 36 inches in height. California code says maximum of 34. So there's a discrepancy there. So you must adhere to the stringent, which is the California code. So you need to make sure that you're dealing with or working with a contractor that knows what he's doing. So this gentleman was so frustrated upon learning that his brand new $10,000 counter was going to cost him an additional $2,500, which is what we quoted, to modify it to meet California and ADA requirements, that his attorney suggested that they fight this. The problem with it, as we learned, he did not end up contracting with ACR. He fought it. I believe he ended up with $20,000 in attorney fees plus another 10 on the other side. So he was so angry and emotional, and most people are when they're hit with these ADA lawsuits, because no one sets aside the capital for it, especially in today's world. So instead of paying the $2,500, getting a cash reinspection to say the work was done right, he decided to fight it, and it cost him thousands of dollars, and he ultimately lost the ruling on it in federal court. Keep in mind, these cases, 99% of them are filed in federal court, not California civil court. So that's some additional information. So going into a second myth, excuse me, the building is owned by someone else, so I'm not liable for the violations. Fact. Compliance is not only the landlord's responsibility, both the lessor and lessee are responsible and liable for the accessibility of a facility's public areas. If you lease or rent a facility, it is advisable to have an agreement with your landlord about who is responsible for providing and maintaining the facility's accessible features. Lease and rental agreements must stipulate whether the property was inspected by a CAS, and if so, whether or not the property is compliant with all the applicable construction-related accessibility standards. So what they're saying is the courts are getting fed up of clogging up the system with these lawsuits as well. So what they want is for the property owner and the tenant to review their leases and provide an addendum with the appropriate language. Typically, in a commercial lease, the property owner is responsible for the exterior. The interior is the liability of the tenant. And most often when these lawsuits are filed, both parties are named. However, in the allegations in the lawsuits, they only name either the outside or the inside, so it creates this confusion. And what the courts are trying to do is, quicken this up as fast as possible by making the lease standard. Okay, the third myth, the standards are always changing, making it hard to stay in compliance. I'm just going to sum up this paragraph for you really quick. The fact is ADA standards have not changed much or at all in 20 years. So the notion that they continually change and you're always fighting to be compliant is not true. Going back into the actual disabilities, most people believe that the disability is confined just to a wheelchair. We have blind, which are visually impaired, people with service dogs, on canes, amputated limbs, and hearing impaired. So keep in mind, these are the disabilities, not simply a person who is in their wheelchair. 4 steps to becoming into compliance. First of all, make sure you get a high quality CASP inspection and the report. We provide them here. It all starts with the CASP report. You'll find a decent CASP report will cost $400 to $1,000. Make sure that you have an expert ADA attorney. We provide that as well through our team. The critical part, hiring the designer contractor that works with the CASP inspection, that works with your team to make sure that you have multiple layers of protection. And we're going to wrap up something here real quick with the 4 steps. The most critical, I believe, is the CASP reinspection. Oftentimes, the owners jump into hiring a asphalt contractor with limited experience. They lead the owner to believe that they are compliant. They end up in their 2nd and 3rd lawsuit. So very, very important that you follow these 4 steps. Quality ADA inspection and report, making sure you've got a good ADA attorney, making sure that whoever's performing the work is an ADA qualified designer, and the CASP reinspection, and making sure all 3 of these principles are working together. So that is a streamlined approach and some information. I hope it was beneficial today. And if you have any questions, again, feel free to reach out to me through my email, City Properties, and we can step aside here if you like to field any questions.
Great. Thank you so much, Tony. That was really informative. Wow. And quick all at the same time. So you had mentioned that you're going to give away, we were going to raffle away one of those CASP inspections.
Yes.
And so we do have a name. I think we are drawing a name right now. The way that you participate is when you register, your name is automatically put in the, it's automatically put on the wheel, and then we have a wheel and it spins, and then a name will pop out of there. And it's like, I think they're retrieving the name right now. And while we wait for them to retrieve the name, I did just want to mention again that, or not again, but for the first time on this live stream, but we've published it in the magazine, and we are asking for you to protest with us. We're asking you to get active and show, there's a picture's worth 1,000 words. And this is in the, oh, you can't really see it very well, but this is in the magazine and in the AOA magazine. And also you can download it, but basically we want to send a picture and we want to send a letter. We have a letter that's already written. We also have a picture with a space where you can write, but we want you to send it to Governor Newsom. We want you to send it to your mayor. We want you to send it to your city council members to tell them why the eviction moratorium should not be extended, because there's tenant right groups that want to see it extended through the end of the year. You see a lot of different things going on, and so it's so often that we just feel helpless. We feel like, well, what's my one little letter going to do? And, this is America, and we do have to stand up for ourselves, and we do have to speak out in order to be heard. And if only one of us speaks out, then nothing happens. But if all of us speak out, then things can happen. And so just want to encourage you to do that. There's the AOAUSA.com /protest, and you'll be able to download it there or just get it from your magazine. And that'll do it. And then here we are with the winner. We have Angela Chavez Monroy. So congratulations. You have a free inspection, from what I understand. That's the initial CASP inspection is what they get free. Is that right, Tony?
Yes, that is true. So it'll consist of the field inspection for the exterior of the property, and then it'll come back with a very detailed report with any corrections that are noted and pictures and measurements and things of that nature. It's a very critical piece of information.
That's great. That's great. And then did you mention that for AOA members, the second report, which is the most important report from what you said, that report, is that also free?
That is at no additional cost to our clients, absolutely, because it's part of our 4-step process. So the multiple lawsuits are occurring because owners are performing the corrections incorrect. There isn't a better way than having a re-inspection of the work to make sure the contractors performed it correctly. So here at ACR, I believe we're the only contractor in California that raises their hand to have our work inspected or insist on it so much that we offer it free.
Incredible. Okay, and you better put that in your contract if you.
It is
right. If you're gonna contract with anyone, you better have that in your contract. That unless it meets this post inspection, you're not getting paid, right? You better be real smart in how you do that. So here we go.
Yeah.
So thank you for that. That's amazing. And so if you're not an AOA member, join. And we're just so excited to be able to give you these kinds of resources. And Tony, just thank you so much. Tony's, speaking of the contractors and vendors, Tony's been one for the last 15 plus years. We mediate cases. If there's things that are going on, you can bring those to us and we contact the vendor. So we try to create a community that's safer. And he's a guy that's just been with us for a long time. Let's get into the questions. And Kang Fu on YouTube, he has a great question. Why are most ADA lawsuits filed in federal court versus state court? Is one jurisdiction more advantageous to landlords over another?
Well, one of the reasons is there's not a lot of practicing attorneys that are familiar with federal court. The federal statutes allow an easier task or an avenue, so to speak, for their corrections. And then they piggyback on some California statutes, which the Unruh Act comes into play. And then California has a statutory amount of $4,000 for corrections, which are always argued against occurrences. So the federal court lends a much simpler avenue for the plaintiff to capture as much as they can.
Got it. All right, Andrew Weissman, thank you for your question on YouTube. Define alterations. If you repair and or paint, stucco, repair or re-roof, renovate a unit, all cosmetic, does that constitute an alteration? And would that trigger an ADA?
Well, that comes down to what we refer local jurisdiction. Local jurisdiction or enforcement is the city that you're within. Every city has a detailed set of requirements. For instance, in his particular city, he may not have to pull a permit for painting and stuccoing. If the city turns around and suggests that, yes, you need a permit to do this type of stucco and painting, then that is an alteration. Now, a lot of cities are different, so you have to be very careful. We recently did a project in a city in Northern California where 90% of the cities do not require a permit for removing and replacing 4-inch concrete non-structural. However, they brought to our attention within their local jurisdiction that if the concrete you're removing and replacing is in the middle of the parking lot, not an issue. But if it's part of the accessible route, that triggers a permit. So then the entire property came underneath compliance.
Right. Okay, Kang Fu again. What is the role of ADA attorney for proactive actions?
Well, here's an example. So the role of where you could use the ADA attorney if you're going to be proactive, one of them would be going back to the leases between landlord and tenant. So I can assure you not all of the leases have that information in them. if the property has a CASP report by the owner and he has not provided that to the tenant, he has put himself in a vulnerable position. The tenant has a right to know if there's a issue with regards to the exterior. So some of the language that they could put in is that as the owner, we're insisting the tenant provide a CASP report to make sure they're compliant. If they're not compliant, they have 60 days to make the corrections. If they do not make the corrections, then if we are named in a lawsuit, we must be indemnified. So there's a lot of things simply within to be proactive that must be clear in the lease. And again, I'm not an attorney, I'm not giving legal advice, I'm giving suggestions on, or answering your question on what I would do in my property with my tenants, is I would be proactive and get the leases in line. In addition to that, if you are receiving questions or comments from CASP inspectors or other attorneys or contractors that you're not quite clear on, then you would consult with an ADA attorney to put you back on track. And the way that I stated in our webinar is always go back to the ADA law from 1990 and the intent. So your legal counsel being proactive can assist you with a variety of items.
Great. And okay, here's John on YouTube. For multifamily properties, 5 units or more, can you please restate the minimum number of apartment units when ADA compliance becomes required?
In new construction, some cities are requiring it, but if you have an existing building, multifamily 5 units, you typically will not have an on-site manager because it's 15 units or more that triggers that. Typically with 5 units, you do not have a leasing office. And if the property was built before 1990 or even today's date, and you are not required to have accessible units, then there's nothing for you to be concerned about. It's only in new construction. I was recently working on a project in the city of Downey, and it was 4 units. And the city of Downey, I believe, was requiring one of the units to be accessible. And that to me was extremely interesting and unusual. The unit, and as I reviewed it for ADA compliance, the unit itself was accessible, but they forgot to include a path of travel. So how do they get to the city sidewalk? So there are a variety of things. So you always have to check local jurisdiction on new construction through your plan check basis. But existing buildings, you don't have anything to worry about unless you voluntarily raised your hand to convert a unit. And sometimes you'll have a tenant that started off residing with you, and over a period of 5 or 10 years, they became disabled. So that presents a whole different set of circumstances that originally it was not an accessible unit. Now they're in the unit, they became disabled, and they're requesting you modify the property. So that's a whole separate set of circumstances that we would assist you through legal counsel. I can go into your process, but we don't have enough time here today. But with 5 units, not an on-site manager and not a leasing office and not existing accessible units, it just shouldn't be an issue.
Great. And that was real key. I thought the distinction between there's ADA and then there's also your local code. And so I thought that was a really good distinction that you made there. All right, Andrew, what do you charge for a pre-evaluation?
Well, there's a difference between a pre-evaluation. The answer to that is nothing. The CASP inspection and the report, I'll give you an example. If you had a small strip center that consisted of 5 to 10 units, the exterior only, let's say it consisted of a liquor store, coin-operated laundromat, which are getting hit hard now by lawsuits, nail salon, video store, something of that nature, where the units are 1,000 square foot average. The exterior CASP inspection and report, quality report would range from $500 to $600, somewhere in that area. The evaluation is simply me coming by, taking a quick look at it and saying, well, your property is compliant, I wouldn't worry about it. Or I see multiple items. So to create the paper trail, which we believe is necessary for compliance, you would start with the CAS report. So I'll come back to you and say, hey, you know what, your property looks great. Or I highly suggest a CAS report and tweaking the design a little bit to meet modern compliance. And then plans if necessary, permits if necessary, and a CAS re-inspection.
Now you talked about coming by. Are you local to one area, or do you cover the whole state?
We cover the whole state of California.
Okay, so you're just going to come on by.
Well, you know, it will be at a selective time. So, for instance, we have Northern California. I mean, it's very simple anymore to fly through JetBlue into San Jose. So we'll look at multiple properties in that visit. Gotcha.
Okay, so they'll just line it up. All right, guys, there you go. Rental on YouTube. To confirm, ADA compliance is for apartment buildings with 15 units or more, correct?
Yes.
Yeah, okay.
There is an organization, just to give you some validation, and you can Google this. It's a interesting group. They refer to themselves as a club, which I thought was interesting, but it's referred to African Asian Club. And what they do is they target apartment buildings 15 units or more. They don't file lawsuits against anybody else, but they file them very specifically against apartment buildings for mainly 3 items. One is the leasing office and not having access to it. The other one is there is no leasing office and the manager wasn't available or simply didn't allow us on the property. And the third one is their websites. So they're getting hard by not having a user-friendly, compliant website. And we can help clients with their websites as well to bring them into compliance. But that particular group, the African Asian, they target 15 units or more, and I believe their legal counsel is in San Diego.
Right. King Fu again, do you need ADA compliant signage at the entry of the parking lot? And do you need ADA compliant parking stalls?
For what type of structure? If it's Title III, meaning it's open to the public, the answer would be yes.
Yeah, and she wrote there that it's an apartment complex that's not considered new construction. So we'll keep going. Roland on YouTube, thank you for your question. In a 3-story apartment with stairs only and tuck under parking, what ADA access do I have to provide?
If it's 15 units or more and it's an existing structure, then you are compliant from the year of construction. They cannot make you put in an elevator unless you are applying for a permit that you're going to add 2 or 3 additional units. Then that may trigger in your local jurisdiction for an elevator. But as it sits now, and especially if it's 15 units or under, it's a non-issue. Although you should consider making the handrails and the stair nose striping on those, bring that at the very minimum into compliance. And that would fall under building code as well, meaning a yellow stripe at the nose of the steps, 3 inches wide, no less than 1 inch from the edge of the nose. And that should be on every riser all the way up. If it's on the interior, it's only required at the top and the bottom, but exterior, and then the handrails, making sure that you have quality handrails.
Great. All right, King Fu again. In California, are you required by law to have a resident manager for a complex that is 16 units or more? Is the resident manager apartment considered a leasing office?
There's 2 ways to look at it. If your property does not have a leasing office, or if you've closed it due to COVID, then I believe it's the 16 or 15 units that trigger or more that triggers an on-site manager. So it's my understanding that California triggers an on-site manager with that many units. So it becomes a question. If I'm a disabled person, I want to be able to, you have a for rent sign either on your website or advertised in the newspaper or on the fence out front of the building. I have to be allowed to view the property. You cannot discriminate against me. You do not have to have an accessible unit. You can simply say, we do not provide any accessible units. You can't ask them the nature of their disability, but you have to at least allow them the opportunity. Otherwise, you are discriminating. So by allowing them means you need to have a path of travel from the city sidewalk through the gate. The gate may be locked. The intercom button may be too high. There needs to be signage. There needs to be the right door lever, the kick plate at the bottom. The door has to open with 5 pounds of pressure and close with 5 seconds. So there's a lot of items that come into play to at least allow a disabled person to review the property. And that's if the manager is on the first floor, then we would create an accessible route to his unit. If he's on the second floor, we have to create a satellite office in the common area, which means a path to an ADA table with a shade structure, could be a palm tree or an umbrella. And the manager has to come down and at least answer questions for a disabled person.
Right. And I know that there is something called a responsible party. So if you have 15 units plus, you don't necessarily have to have an on-site manager, but there's a person that you would designate. So it really depends, everything that you're saying, it kind of depends on that, whether would it depend on whether they're an on-site manager or responsible party, or that one I'm not so sure. But it seems like, hey, you want to love everybody and take care of everybody and be accessible, right? Anyway, but when it comes to investment property, I know everybody listening, you're like, I only want to do what I have to do. And so we know where you're coming from too. All right, Jennifer, on YouTube, if an existing 1970 apartment building in San Diego with over 90 units with a leasing office that is on the first floor and is accessible, but we're all on a hill, do we need to make any changes?
Well, the first question I would ask is it accessible according to California federal law? You will not know that until you do a CASP report. So the very first thing, 90 units, I would highly suggest a CASP report. Now that CASP report is going to trigger other issues based on local authority at the time the building was built. 90 units, often they have a disabled parking stall as well on site. So those are things to consider. So you do need to provide access to the leasing office. And if you're on a hillside or a slope, that's where the designer comes in. So the designer can create something. If it's physically impossible to meet the codes, then we highly suggest that a set of plans and permit be acquired. The reason for that is you cannot allow a contractor or an architect or an attorney tell you that you can't physically do it, so just don't do it. You need local authority, meaning the city, to tell you that, okay, you cannot meet compliance, it's a physical hardship. However, you are required to provide the next best alternative. And that would be local jurisdiction that makes that decision. The way they make that decision is the ADA designer works with the city. They put a plan together. It's usually going to be 3 or 4 revisions till they come up with the right solution for that property. Now you have an approved set of documents and a permit and a CASP pre-inspection.
Next week, we have Dennis Block speaking. And so you'll want to tune in for that one. As well, we also have a title, let's see, it is Smoke Damage, Maximize Insurance Claims and minimize liability. So these are two different topics that will help keep you in the know. So you're going to want to sign up for those, register for those on the AOAUSA.com website. If you like this kind of content, go ahead and subscribe to this YouTube. We're not monetizing this. It's just for you. And then you can toggle the notification bar. And then that way, whenever we go live or post new content, you'll be aware of it. And so it's just to keep you in the know. There's a free email newsletter. Definitely would love for you to sign up for that. It's on the AOAUSA.com website. And, if you hadn't registered for the event this time, you lost a chance to, that chance at that inspection that was worth like $400, $500. So definitely register for events. And then that way you'll be put on the prize wheel whenever there's something to be given away. And we're real thankful for you guys. And I wish you the very best at providing housing. And we will see you next week.